Mr. Bradley. Your name's Alexander Bradley?
Alexander Sherrod Bradley.
Okay. Sherrod is your middle name?
Correct.
You also go by the name Rock?
No, I don't go by the name Rock.
I heard the jail calls and your aunt refers to you as Rock. Was she speaking to someone else?
I believe you might have heard her say Rocky.
They call you Rocky?
My family, yes.
Okay. And you're also known as Sherrod?
That's my name, yes.
Shooting Sherrod in the streets?
Objection.
That's what you said.
I'm asking you, are you known as that?
No,
You didn't ask me a question, sir.
overruled.
Are you known as that?
No, sir.
Okay. And they call you Rock because you rock people to sleep?
Objection.
Not correct.
Straight.
No, that answer may stand. The answer is no.
My question to you, though, sir, is who are you really?
Objection. Sustained.
I say that because I'm reading some of these text messages, and you talk about, I'm a 100% gangster, nigga, for real, stuff like that. Those are your words, right?
If that's what you're reading.
Those are your words, right? You said those words?
If
You
that,
used those words?
Do you recall those words, sir?
some of those words, yes.
Okay. But as you're here in court, of course, I have a little different tone, like,
Objection. Sustained. Put a question.
yes. Did you say Mr. Hernandez is the gentleman sitting in the blue suit with the gray tie at council table, sir?
Objection. Put a question, please.
Did you say that earlier yesterday?
Objection. Sustained.
Mr. Bradley, some of these text messages, let's get these text messages a little bit. I'd like to discuss the context of the text messages. Do you understand?
Yes.
Okay. You had just gotten back from Florida?
Are you asking me a question?
Yes.
Yes.
Okay. And you retained a lawyer?
At some point, yes.
Okay. In fact, one of the earliest messages, you reference a lawyer, right?
Can I see
recall
that?
that?
Can I see that document, please?
Sure. For counsel, text message 16. May I approach the witness?
You may.
Yes,
Okay.
that's correct.
So out of the 400 and some odd, I'll get the exact number, 479 text messages. By message 16, you're already telling Aaron about your lawyer,
Correct.
right? And what you're doing is you're building a case, right?
I don't believe so.
You're communicating with your lawyer,
Oh, correct.
okay? And your lawyer's even sending you the complaint?
Objection. Put a time frame on that, please.
At some point during these text messages, your lawyer sends you the complaint
At some point, yes.
and asks you to send that to Aaron?
Objection. Sustained.
You, at some point, forward a civil complaint to Aaron to show him that you're not messing around,
Correct.
okay? And throughout this time, from the very beginning, you're talking about all of this legal business, right?
Early on into it, at some point, yes.
Okay.
At that point, yes.
And you're talking about you want to get compensated,
Correct.
okay? And you're threatening to ruin Aaron's life.
I don't believe I threatened to ruin his life. I may have.
Okay. You're also threatening to take his life, right?
Well, yeah, I was threatening to take his life. But I believe I said I didn't want to ruin his life.
But if you file this lawsuit, you're going to ruin his life, right?
If I'm forced to, yes.
Okay. Now, out of these text messages, I'm going to go through them a lot quicker than Mr. Hagan, but I want you to note that you're in black text. Aaron's responses are in blue. You see that?
Correct.
Okay. There you see all of yours, all of the messages here on this page are yours with the exception of 2, right?
Correct.
All of these with the exception of 1 is you, right?
I can't see the full document on my computer. If you slide it down, please. Correct.
All of these except 1 is you, right?
Correct.
All of these except 2 are you, right?
Push the document back up, please. The other way. Correct.
All of these except 2 are you, right?
Correct.
All of these are you.
Correct.
All of these are you.
Correct.
You.
Correct.
All of these except 2 are you, right?
Correct.
All of these are you.
Correct.
All of these except 2 are you.
Actually, I'm sorry. The document before that, I said correct. They weren't on me. 1 was him. The page before that. There you
I
go.
said all of them except 1. Correct? All of these
All except 1, correct.
except 1. All right. All of these except 2 are you.
Correct.
All of these except 3 are you.
Correct.
You minus 1.
Correct.
And these are 5 that are Aaron's.
Correct.
Another 5. No, yeah, 5 that are Aaron.
About half, correct.
All you minus 2.
Correct.
All you minus 3.
Correct.
Again, 3 for Aaron.
Correct.
2 for Aaron.
Correct.
1. I'm sorry, 2 here for Aaron.
2, correct.
All you.
Correct.
All you minus 1.
Correct.
All you minus 2.
Correct.
All you minus 3. I didn't hear it correct on that one.
I couldn't see the bottom of the document. You flipped too fast.
How about there?
Correct.
All you.
Correct.
All you minus 1.
Correct.
All you minus, he's got 5. About half of them are his and half of yours, right?
Correct.
All minus 1.
Correct.
You
Correct.
completely.
Correct.
You completely.
Correct.
You completely.
Correct.
You completely.
Correct.
All of these statements, you're anticipating litigation, right?
Yes, after a certain point.
Okay.
Yes.
And all of these statements are made in anticipation of litigation, are they not, sir?
No, overruled.
Correct.
Okay. All of these are you too, right?
Correct.
You again.
That 1, yes. Correct.
Okay. All of these are you again.
Correct.
All minus 2 are you.
Correct.
All of these are you except 1.
Correct.
All of these minus 4 are you.
About half, correct.
All these minus 2 are you, right?
Correct.
These about 4 that are Aaron's, right? Right?
Yeah, about half, correct.
All you here.
Correct.
All you minus 2.
Correct.
All of you.
Correct.
All you again.
Correct.
All you minus 1.
Correct.
All you, sir.
Correct.
All you again.
Correct.
All you again.
Correct.
Okay. And throughout this time, at least from text number 16, we know you're in contact with your lawyer, right?
Correct.
Okay. And in here, some of these text messages, well, these aren't all your text messages, right?
All right, what, and you gotta show me what you're talking about. If you're just talking about the documents.
These are just the text messages between you and Aaron, right?
Correct, the ones you just showed, yes.
Okay. And in these text messages, you're threatening him and you're telling him all the evidence that you got, right?
Yes, for a civil matter, correct.
Okay. And that's basically to push him to settle,
Correct,
okay? And you're telling him about the guy who found you in the alley
correct,
and how he said he saw a white SUV.
correct. I
You
believe
know
I
that to
said
be true or not?
I know I said that.
Okay. I know you said that.
Yeah.
My question is, do you know that statement to be true?
I don't recall.
If you recall being told that the gentleman said it was a dark SUV that left, not a white one.
I don't recall someone telling me it was a dark SUV either.
Okay. And then you talk about cameras in the alley.
Correct.
That wasn't true, was it, sir?
No, that is true, sir.
Okay. So there's cameras in the alley that show Aaron Hernandez shooting you.
I didn't say the camera showed him shooting me. I said there was a camera in the alley.
Okay, there's a camera in the alley showing you getting shot or you being walking around.
I never said the camera showed me walking around either.
Cameras in the alley showing anything.
I said there was a camera in the alley, sir.
Did you see any video from any camera in the alley at any point in your lifetime?
No, I was informed that the camera didn't work, actually.
Okay, so you're telling them all these stories, you're telling them everything you got, right?
Correct.
And that's to really extort him for money, right?
Objection. Sustained. Rephrase.
In these 479 text messages, that you don't mention at all actually, let me rephrase that. You said back in West Palm Beach that the reason you got shot was because you said because of that stupid shit you did up in Boston,
Correct.
right? And that's what precipitated this whole thing.
Actually, I need to correct myself. I didn't say that was the reason that I got shot, because of him saying that stupid shit. Because of me telling him that stupid shit you did in Boston.
So you want to change your testimony now?
It's not changing my testimony, sir.
Or you want to correct yourself?
It is my memory that I just indicated that he said that I said that to him.
Okay, but so then that's not the reason you got shot, because you knew that he had shot some people up in Boston, right?
I don't definitively know.
No, overruled.
Go ahead.
I don't know the exact reason that he shot me.
Okay, so you tell him all this evidence you got about him on the Florida shooting, but you don't say a word in these 497 text messages about the big thing you got on him, which is the double homicide in Boston, correct?
Not correct.
There's not a single text in here that says anything about Boston.
There's
Right.
there's false. There's an implication of that.
Okay, well, let's see that implication. Yeah, proceed witness.
You may.
Take your time, sir. Find us the implication where you reference the double homicide in Boston.
Found it.
All right. Give me the number. I'll put it up on the screen.
Text number 50.
Okay. I'm gonna zoom in. Hold on a second. All right. Here you say, I chose to handle it. Well, I'm going to go up a little higher to give it a little more context. Let me start. Listen, you're no dummy. If you were smart, you'd know I ain't trying to ruin you. If that were the case, I would have told on you. I'm so G, plus I loved you so much, I chose to handle it his way. I'm sorry. His way, which means I still do love you, but you tried to take me from my kids and my life away. You owe me for that double A. Now,
Correct. And
you're saying, your assertion is that you used the word double A, and that means that he committed a double homicide.
yes, that's what that was. He knew what it was.
How do you spell Aaron?
I don't know how do you spell it, sir.
I'm asking you, how do you spell Aaron? Do you know how to spell it?
And no, I don't know how to spell. I know there's different ways to spell Aaron. How would you spell
How do
Aaron,
you
sir?
think Aaron Hernandez is spelled?
I don't like to speculate. How does he spell it, sir?
A-R-O-N.
Oh,
Okay, so there are two A's in his name, first name.
correct.
Would that be double A?
If that's how it's spelled, yes.
Okay. And according to you, that means double homicide, right?
Correct, because if you look at the rest of those documents, never at any other time do I normally address him double A. That's why that was a
So just
subliminal.
because you don't call him double A again, that means you're referring to a double homicide.
Yes, it was a subliminal message to him about the double homicide. Correct.
Speaking of subliminal messages, on your second interview on October 18th with the police, the last question asked to you by Mr. Hagan is, do you recall?
Objection to subliminal messages.
No, that may stand. It's the witness's testimony.
Mr. Hagan, do you recall Mr. Hagan asking you if there's anything that you know of that could support what it is that you're saying? You said, search his iPad or his records, and I think he refers to himself as double A. Do you remember that?
Yes.
Okay. And apparently, Aaron likes to rap.
Correct.
Okay, and he uses that reference when he raps.
He used it during a rap in a
Okay,
reference to a particular situation, which is the matter at hand.
and that's of course according to you.
Correct.
Okay, you have nothing to corroborate this whatsoever except your word.
If there's no iPad and evidence, yes.
Okay, well, let's take a look at your word. Sir, do you recall Mr. Hagan asking you about some of the things you said in your jail calls before being brought over to Boston? You remember that
Correct.
yesterday?
Yes, I do.
Okay. Now, let's put this in context for the ladies and gentlemen of the jury. You're subpoenaed to come to the grand jury, right?
Correct.
And you don't show.
Correct.
And you don't show because you think if you show, you're in trouble.
I believe it's a possibility. Correct.
Okay? And you got your own interest at heart here, right?
At this point, yes.
Okay. So, the police come get you because you don't show up, right?
Correct.
They hold you on a $250,000 cash bond.
I believe it was higher, but it could be right.
Okay. And you start making calls to your family,
I made a call to my daughter's mother. Correct.
okay? Brooke Wilcox,
Correct.
right? And you talked about some of the statements you made to Brooke yesterday. You mentioned them, right?
I believe they were mentioned, correct, yes.
Okay. Well, let's say exactly what you said. You recall saying, I don't know shit about that shit.
Yes,
And you're referring to Boston, right?
correct,
Okay. And then you say, they are just going to ask me about a bunch of shit that I don't know.
correct,
You're lying, right?
yes,
Okay. You're lying, Brooke,
correct,
the mother of your daughter.
yes,
Okay? And then you say on October 6th, they sound dumb as fuck. How's my testimony crucial? You remember saying that?
vaguely, yes.
Okay. You're lying again.
At the time, I wouldn't know,
That's your word. Those are your words, right?
or you're not allowing me to answer.
Please, go ahead.
But
Go right ahead,
at the
sir.
time, I didn't know if my testimony was crucial or how crucial it was or not.
Okay. But you don't know shit, right? That was a lie.
That was a lie, correct.
Okay. That's your word, right?
That was my word, correct.
Okay. And then you say, I can't see how they're saying how I may have been in the car. That's the most bogus shit, man. That's a lie, right?
I don't recall that part, but can I see that?
Sure. That's fine. Okay. Right there.
Correct.
Okay, and then on October 6th, you say, I don't know shit. That's why they're dumbasses. Can't wait to get up there and tell them how stupid they are. Remember saying that?
I don't recall, but if it's on there, I'm sure I said it.
Okay. Did you get up there and tell Mr. Hagan how stupid they are?
No.
Okay. But that was a lie, right?
What was a lie?
That how stupid they are.
Objection.
Sustained.
Did you come to Boston? You said you couldn't wait to tell them that they're dumbasses? Did you tell them they're dumbasses?
Overruled.
If that's what the document says, then that's what I said.
My question to you is, did you tell them that they're dumbasses?
No.
Okay. No, that's when you cut a deal, right?
At some point, I cut a deal. I don't know if, that's exactly when, but at some point.
Now, you keep talking about at some point. You're brought over on October 8th. Do you recall that?
I believe that's accurate.
Okay, and you have your lawyer there,
Correct.
and that's a Mr. Pickering.
Correct.
You call him Pick for short.
Correct.
Okay. You're close like that with Pick, right?
Objection.
No, you may answer that.
You're close like that with Pick, right?
He's my lawyer.
You call him Pick.
Objection. Asked and answered.
Sustained.
Okay. So the Commonwealth and Pick start talking, right?
Objection to the constant referring as pick.
Uh,
I have a later
Rephrase.
reference to it, Your Honor.
I'm sorry?
I think it's relevant. I have a later reference to it. The court will indulge me on
Yep.
the Pick. Okay, so the Commonwealth and your lawyer start talking, right?
At some point, yes.
Your lawyer starts telling them things.
Objection.
I'll see you at sidebar. Mr. Bias,
May I approach the witness?
you may.
Mr. Bradley, I'm showing you your letter from the state attorney's office to you. Do you recognize that letter?
Yes.
Okay. And it's 3 pages, right?
Correct.
And that's your signature right there?
Correct.
Dated October 8, 2013?
Correct.
Okay. Judge, at this time, we would move to introduce the immunity letter issued by the Commonwealth of Massachusetts to Mr. Bradley as an exhibit.
All right, without objection, that is received.
301.
All right, ladies and gentlemen, I want to give you an instruction with regard to the exhibit just received. The exhibit just received was described as an immunity letter. I think it's more properly dubbed a cooperation agreement. That is, it expresses an agreement between the Commonwealth, in this case represented by the Office of the District Attorney, and this witness, Mr. Bradley, where the Commonwealth is expressing, I suppose you could call it a benefit, that is a statement that the Commonwealth will not prosecute Mr. Bradley for anything he may tell them in connection with the instant case, in exchange for Mr. Bradley's full cooperation. And the agreement also reflects that before Mr. Bradley appears under oath in a court proceeding, either before a grand jury or before a trial, that the Commonwealth will seek, that is, petition the court for an order of immunity, that is, a grant of immunity by the court to a witness for anything a witness may say as part of their testimony in a court proceeding. Immunity means that the person could not be prosecuted for any matter that is the subject of their testimony. In introducing this agreement as an exhibit, please understand that it is not an expression of the truthfulness or lack of truthfulness of a witness's testimony. It is not a statement or reflection that one side or the other, in particular the Commonwealth, in granting or entering into this cooperation agreement, is in any way vouching for the truth of the information provided by Mr. Bradley, and where a witness is testifying pursuant to some cooperation agreement or some plea agreement, or testifying pursuant to a grant of immunity, that is, where a witness has received some sort of promise or benefit, then under those circumstances, a jury should examine that witness's testimony with great care and caution. That is, understanding and considering the fact that some benefit or promise has been made in exchange for the information granted. Mr. Baez, you may continue.
Thank you, sir. Mr. Bradley, when you got taken over to Boston on October 8th, you were aware this was being negotiated, right?
Objection.
No, overruled.
No.
You had your lawyer there?
Right, when I came on the 8th,
Yes. On the 8th?
I wasn't aware that there was anything being negotiated. Actually, there was. Explain what you mean by
Okay,
negotiating.
well, you read this letter, right?
Correct,
You signed it,
correct,
and you understood everything in it.
correct,
And if you didn't understand anything in it, you had your lawyer there to be able to explain to you what certain paragraphs meant.
correct.
Okay? And you took advantage of that legal advice.
Objection.
No, you may answer that yes or no.
Correct.
Okay. Now, let's go over that with the ladies and gentlemen of the jury real quick, section at a time. Okay. This letter is addressed to your lawyer, correct?
Correct.
Okay. And here it says, "It is my understanding that your client, Alexander Bradley, has certain first-hand information that may be relevant to the investigation and prosecution of July 16, 2012, shooting homicides of Daniel Abreu and Safiro Furtado in Boston." See that?
Yes,
You understand everything there, right?
yes,
Okay. The next paragraph says, "Specifically, it is my understanding that on July 16th, at approximately 2:20 a.m., Mr. Bradley operated a motor vehicle in which Aaron Hernandez was the passenger. It is my further understanding that Mr. Bradley made certain observations in the fatal shooting at this intersection of Harold and Shamet Avenue in Boston. Additionally, it's my understanding that Mr. Bradley did not discharge a firearm at any time on July 16, 2012. You see that?
Yes,
You understand all that?
yes,
Okay, so before getting this letter, your lawyer told Mr. Hagan that one, you saw Aaron Hernandez shoot these two men, and two, that you did not fire a gun.
Objection.
Is sustained in that form.
When you see this information was already given to the state for you to get this letter, right?
I'll see you at sidebar.
Question again, all right? So, before you are able to sit down with the prosecutors, your lawyer has already told them that you were driving the car, correct? I'll actually compound the question if it makes it easier, okay? That you were driving the car, you saw Aaron do the shooting, and you didn't shoot a gun that night.
no,
That you were driving the car, you saw Aaron do the shooting, and you didn't shoot a gun that night.
no.
To someone for the Commonwealth.
It was my understanding,
That's what the first paragraph refers to, correct?
correct.
Okay. I think the judge has an
What?
instruction at this time.
All right, ladies and gentlemen, to the extent that is information that was communicated by a third party, in this case by an attorney, to someone for the Commonwealth, that could be hearsay. That is, if it were presented for the truth of what was contained in that statement, it would be hearsay and not admissible. I'm admitting this question and the content of what is in this agreement, not for the truth of what was said, but for the fact that it was said. That is, it was a representation made prior to Mr. Bradley speaking to police officers or prosecutors. Mr. Baez, you may continue.
All right, the next paragraph reads, sir, based on these representations, the following sets forth the agreement entered into between Suffolk County District Attorney's Office and your client, Mr. Bradley. Do you see that?
Yes,
Okay. This is the agreement that you guys entered into. Mr. Bradley agrees to provide a complete and accurate proffer. Well, let's stop right there for a second. You understand what the word complete means, right?
yes,
Okay. And you understand what the word accurate means, right?
yes,
You're aware of the phrase lying by omission, right?
I'm aware of the word lying.
Okay. Do you know what that means, lying by omission?
No, can you explain it to me, please?
Sure. It means when you tell half the truth, you don't tell the whole truth.
Objection.
Now overruled.
You understand?
I understand that.
Kind of like your oath. Swear to tell the truth, the whole truth, and nothing but the truth. You understand?
Correct, yes, I do.
So complete means everything, right?
Yes,
Okay. And accurate means truthful, right?
correct,
That's what it means to you too, right?
correct.
All right. Now, proffer regarding the above described incident. No statements made or other information provided by Mr. Bradley during the proffer will be used by the District Attorney's Office against Mr. Bradley in any judicial proceeding. That basically means to you, right, that whatever you say can't be used against you in any proceeding, except, and we're going to get into that. Do you understand that to be correct?
Correct.
All right. Now, except as for the purposes of cross-examination, rebuttal, or impeachment, should Mr. Bradley offer testimony or evidence in any proceeding which is materially different from any statements or information provided during the proffer. Do you know what that means?
Yes,
Okay. It means, let me see if I want to be clear. Does it not mean that if you lie or you say something, they can cross-examine you? Listen. They can cross-examine you or rebut what you say.
correct.
Right?
Yes, that's what that
Okay.
means.
And then section B says, in a prosecution based on false statements made or false information provided during the proffer. Do you understand what that means, sir?
Yes,
Okay. Does that not mean to you, sir, that if you lie, they can prosecute you for perjury,
Yes.
okay? Have you been charged with perjury yet, sir?
No, sir.
Okay. This agreement, I'm sorry, in the prosecution for the Proffer, this agreement not to use Mr. Bradley's statement against him applies only to those statements made during the course of the Proffer, which certain and specific investigation, which pertain to the specific investigation set forth above. You understand those words?
Yes.
Okay. Next, Mr. Bradley agrees to provide complete and truthful information to law enforcement officials investigating the above described incident. You understand what complete and truthful mean, right?
Yes.
Okay. Again, we're using that lying by omission, complete, right? You understand that?
For the fourth time, yes, I understand.
All right. Now, well, we're going to go over some more, so don't worry. Next, truthful. This is different than accurate, but it means the same thing, right?
They don't mean exactly the same thing, but they're close.
Okay. What's the difference between truthful and accurate to you, sir?
Truthful means the truth. And
Accurate?
means accurate.
Okay. But in this context, it means something different to you.
Objection, relevance.
No, you may explain the difference in your mind between those two terms.
Accurate means, in my opinion, accurate means, precise, almost precise or close to it. Truthful means truthful.
Okay. And truthfully, before any grand jury investigation, the above described incident, and any subsequent hearings and trials relating to the same, Mr. Bradley agrees that he will neither withhold any information. You understand what withhold information means, right?
Mr.
Yes.
Baez, I think it's not on the screen completely.
Oh, sorry.
Thank you.
Apologize.
Yes, I do know what withhold information means.
Okay. In his possession, nor provide any false information. Do you understand what that means, sir?
Yes.
Okay, so you're not to provide any false information. You understand that clearly, right?
Yes.
Okay. Mr. Bradley acknowledges that no law enforcement official has threatened him to cause him to provide the information. You see that?
Yes.
Okay. No law enforcement official has made any promise to him to cause him to provide the information. You see that?
Yes.
And C, that no law enforcement official has told him what to say. Do you see that?
Yes.
Okay, I want you to pay close attention to section C, that no law enforcement official has told him what to say. Do you remember that from when you signed this?
Yes.
Okay, and you remember that throughout your dealings with law enforcement and the prosecutors, right?
Yes.
Okay, and other than to tell the truth in any interview or testimony he shall give. Now, paragraph 2. Subject to the conditions set forth in paragraph 3 and 4 below, in exchange for Mr. Bradley's cooperation as set forth in paragraph 1, and upon satisfaction of the district attorney that Mr. Bradley was not the individual who fired the weapon that killed Mr. Abreu and Mr. Furtado, or that he directed any individual to commit the act, the district attorney agrees not to prosecute Mr. Bradley for any crimes arising out of the actions related to July 16, 2012, shooting homicides of Daniel Abreu and Safiro Furtado in Boston, right?
Yes.
So what this is saying is you got to convince the district attorney that you aren't the shooter, right?
False.
You
It's
see
not-
what that says?
My
Upon
inter-
satisfaction.
But you want me to tell you what my interpretation of this is?
Well, I'm going to repeat that section, and then you can tell me what your interpretation is. And upon satisfaction by the district attorney that Mr. Bradley was not the individual who fired the gun that killed Mr. Abreu and Mr. Furtado, that he directed the individual to commit the act, the district attorney agrees not to prosecute Mr. Bradley. What does that mean to you, sir?
What it says.
Okay. So basically, so long as it's upon the satisfaction of the district attorney, they won't prosecute you, right?
Right, but that's not what you said. You said it's my job to convince them.
I don't believe I used the word job, but okay, I'll take your word for it.
Say convince.
Maybe not. You know Mr. Bradley, I'm sorry, you know, Mr. Bradley, that Mr. Hagan is not the district attorney, right?
I didn't know that. I thought he was a district attorney.
You understand that he's the first assistant district attorney, right?
I now know.
Okay. He's a pretty big guy over at that office, right?
Objection.
No, overruled.
You understand that, right?
Yes, I do understand that.
Okay. Now, next is the district attorney further agrees to submit an application for judicial immunity pursuant to, and then it gives certain statutes, prior to Mr. Bradley's testimony before the grand jury. You understand that?
Yes.
Okay. This agreement is contingent upon the truthfulness of the information that Mr. Bradley has provided and will continue to provide to law enforcement officials investigating the above described incident. Do you understand what that paragraph means?
Yes.
Okay. Does that paragraph mean to you that not only should you tell them the truth during the proffer, but you should continue to tell them the truth throughout the process?
Yes.
Okay. Now, this agreement is also contingent upon Mr. Bradley providing complete and truthful information. Those are those words again. Do you remember those words?
Yes.
Okay. And the testimony before the grand jury and subsequent hearings or trials. Following the testimony of Mr. Bradley before the grand jury, if the district attorney learns that the information or testimony that Mr. Bradley provides after the date of this letter is not complete and truthful, then the district attorney may declare this agreement null and void. Do you understand that?
Yes.
Okay. So if Mr. Hagan finds any information that's not true, he can declare this agreement null and void, right?
Correct.
Have they declared it null and void yet?
Not as far as I know.
Okay. Should the district attorney declare this agreement null and void because the information or testimony provided by Mr. Bradley is not complete and truthful, the district attorney may institute a prosecution for perjury. You see that?
Yes.
So not only do you know that Mr. Hagan can declare this agreement null and void if you tell a lie, he can also prosecute you for perjury.
Correct. Yes, I do understand that.
And if the agreement is null and void, you could possibly face charges
Yes.
on this case.
I understand that.
Okay. This letter reflects the complete agreement between the district attorney and your client, Alexander Bradley. Only a writing signed by all parties may modify it. If you do not agree to this letter if you agree that this letter accurately describes the agreement between the district attorney and your client, please confirm this by signing the appropriate space below. You understand that?
Yes.
And that is your signature, sir?
Correct.
As well as the signature of your lawyer?
Yes.
Now, sir, you testified that you've been dealing in marijuana. Yesterday you said since 2007. Do you recall that testimony?
Yes.
Okay. But in fact, you have a conviction for sale of narcotics in 2006, do you not?
Yes, I do.
Okay. So that statement was false, right?
Objection.
No, you may answer that question. You may explain your answer.
That statement
Yes.
that you started dealing in 2007 is not true.
Objection. Not accurate.
Not accurate.
No, you may answer and explain.
You said marijuana. Is marijuana considered a narcotic?
Yeah.
Is it?
Yes.
Okay, well, marijuana, I've been dealing since 2007. In 2006, I was dealing what I knew was a narcotic. I have a conviction for, it was a cocaine conviction.
I'm sorry, can you repeat that last part?
The conviction was not for marijuana in 2006.
Proffer, you're playing semantics with the words, narcotics versus marijuana.
Sustained.
Now, this narcotics, so you began dealing in 2006? Is that your testimony?
No, that's
Dealing
not,
drugs.
that's not my testimony.
Okay, well, I want to ask you your testimony now. So you began dealing drugs from 2006?
That's not accurate.
Okay, when did you start dealing drugs, sir?
Sometime before about the year 2000.
2000.
Yes.
So from the year 2000 until now, or until you got, I guess, or are you still dealing?
Sustained.
From the year 2000 until at least 2017, you've been dealing drugs.
It's not accurate.
The answer may stand.
It's not accurate.
That you agree with,
That's not accurate.
okay? From 2000 until when have you been dealing drugs?
From 2000 up until I became incarcerated.
2000 and what?
It's been over almost 3.5 years that I've been incarcerated.
2014.
Correct.
Okay, so for 14 years, you've been dealing drugs, right?
Yes.
Okay, and dealing drugs is a very violent business, is it not?
It can be.
Okay, when you deal drugs, it's a very violent business, right?
Sustained. Well, no, I'll see you at sidebar. Brief pause now, or a morning recess now. All right. Why don't we take 20 minutes? We'll resume at 12:05.